Kei timata tātou o tēnei hui mō te karakia. Tuia, tuia, tuia te taura tangata ki te aroha maurua. Kia maia, kia marama, kia tapatahi te kākahui i te tangata ki te kahu taurima e mauai. Ko te korani, ko te koraroa, haumi e, hui e, tai ki e. This karakia was developed by our people and reflects our values and our way of working. So, kia ora koutou, ko Kerry Ann rānei ko Kerry tōku ingoa, no o Kauea me Motere ki Matakana me Wairau me Mangamaunu o Kutipuna, kei te noho au ki o Tautahi. My name is Kerry. I'm a trustee based in Christchurch and I've been working at Public Trust for just over 6 years. Sue.
Kerry. Hi, I'm Suzanne Woodall. I'm a senior trustee working out of the Kapiti Customer Centre. I've been with Public Trust for near 19 years and I live with my family in Waikanae.
Cool. Thank you all for joining us today to kōrero and raise awareness about the importance of estate planning. We'll now launch into the presentation. We have you on mute, but if you have any questions, pop them in the Q&A, which is beside the chat button, so that we can address them when we pause, or you can reach out to us after if that's easier. We'll start off with a short overview of who is Public Trust. Our whakapapa started here in Aotearoa just over 150 years ago in 1873, the first public trustees service ever in the world. We are an autonomous Crown entity established to provide professional and impartial trustee services. Public Trust's duty to advocate for New Zealanders extend beyond protecting estates. We were among the first government departments to hire women in the 1890s and to provide Māori and Pacific scholarships in the 1990s and to fight for the recognition of mental illness in the 2000s. Our people reflect the diversity of New Zealand society as we work to protect and grow the legacy of all New Zealanders. We are New Zealand's largest provider of wills and estate administration services. So what do we do at Public Trust? We work with people to write their wills, enduring powers of attorney and trusts. Each year we write approximately 7,600 wills and manage the legacies of 1,400 of our customers through administering their estates upon their death. We also support vulnerable New Zealanders to help ensure they are looked after. We provide professional trustee services and we help many people protect their legacies for future generations. Sue.
Thank you. We're here to help New Zealanders with enduring powers of attorney, which enable you to make decisions on someone's behalf if they are unable. We also provide a variety of trusts, family, funeral, and charitable trusts. We either act as an executor and trustee for estates, or we provide the legal and administrative support to other executors and trustees. Perhaps less well known, each year we audit the financial records of individuals appointed by the court as a property manager for an incapacitated person.
So let's talk about what happens when you die. We should note that only around 50% of New Zealanders have a will. Not having a will in place when you die can leave loved ones facing legal and financial difficulties. It's not an ideal situation, Sue?
That's right. We have, with wills, we have a variety of priorities for an individual. They could be summarised as either an emotional legacy, a social legacy, or spiritual legacy. The emotional legacy, we may want our loved ones to be left with an enduring sense of security and stability, that they have been nurtured in an environment of safety and love. The social legacy, we may want our loved ones to have learnt the fine art of relating to people. If they learn how to relate well to others, they'll be well set up to cope with the game of life. The spiritual legacy, we may also want to leave a legacy of the attitudes and beliefs about spiritual matters. Our recent research identified that 85% prioritise leaving an emotional legacy, that is, leaving our loved ones with an enduring sense of security and stability. Yet half of New Zealanders don't have an up-to-date will.
So true.
As someone who has been with, with public trust for some time, I find it really interesting that the statistic of 50% not having a current will has remained in that time. So at Public Trust, we are reaching out to people through organisations such as Red Cross to provide some information on how to preserve your legacy.
Fantastic.
Thanks, Kerry.
A will is a legal document that is uniquely yours. It is your estate plan, where you name who is responsible for carrying out your wishes and sets out specific directions covering common matters, like what you want to happen with your assets, or if you have children, you can name guardians who can be involved in decisions about them. An estate comprises all of the person's sole assets and liabilities at the time of their death. When we think about what assets we have in our name, our sole name, often KiwiSaver is overlooked. Over 3.5 million people have been recorded to have KiwiSaver, and the average balance is now over $30,000. So,
thanks, Kerry. So in your will, you can provide for a variety of people, family and friends. You can leave instructions about a guardian to look after your minor children. You can leave or appoint a special trust advisor that can be there to work alongside Public Trust. If you have an estate where your residuary beneficiaries are maybe young adults, and that we can work with a special trust advisor that can help us manage the assets of the estate to assist those young adults, or if there is funds held within Public Trust, the special trust advisor is somebody that you've appointed to work with us on how to manage those funds. You can also leave your mementos, like your special precious things. You might have some precious jewellery or some precious artwork, or you might even have a Sharesies account or a crypto account. You can leave that in your will. You can also leave bequests. You might have some favourite charities. There's a wide variety of charities you can leave a bequest to. And so your estate is your wishes of your assets of when you pass. So it's a very important, can be very detailed legal document. Thanks, Kerry.
Thanks, Sue. So other common matters to consider are your funeral wishes. We know that this will be a difficult time for your loved ones. So specifying your funeral wishes in your will could take the stress out of big decisions, may save disagreements and further heartache within the whānau. We strongly encourage you to have that conversation with your whānau before your time comes. A statement of wishes or statement to accompany your will. This document is not legally binding, but helps to explain your decisions and why you have made your will the way you have. For example, explaining why you've decided to leave a child or your spouse out of your will. It is an opportunity to provide a message or other special instructions to your loved ones, and it also confirms that you understand certain New Zealand legislation that may affect your will and the rights of beneficiaries challenging or making a claim against your will. If any of these matters applies to you, then you should probably have a will. Okay, so
Thanks, Kerry. A common question that we get asked is how often should we come in and update our will? And we usually would say, as life events happen, and that can be every sort of 2 to 3 years. Things that can prompt a will change are relationship changes. You might have a new child, you might have a new significant asset like a house or a KiwiSaver or even a life insurance. So we recommend you updating your will, with changing circumstances. You're at different stages of your life. So it might be that you're just starting out, or it might be that you've repaid your mortgage and now you've got savings.
Yeah. A common term we're asked to explain is executorship. An executor has the important task of carrying out the instructions in your will or executes your estate. This process is called estate administration, which includes a range of financial, legal, and administrative tasks like collecting assets, closing bank accounts, paying debts, and filing tax returns. The executor will also liaise with the beneficiaries to keep them abreast of what will happen. And the executor can also be a beneficiary, but would need to act in the best interest of the estate and all beneficiaries. Transparency is required. Would you agree, Sue?
Absolutely. Does it have to be a lawyer there, Kerry?
No, it does not have to be a lawyer. But it does take time. So some of the issues we've seen over the years that the executor may be faced with are dealing with grief, conflict, estranged relationships, time. So 20 hours minimum, and that's without a house. With a house, 35 hours plus for a house. Working with overseas assets or families overseas, and that's becoming more common as well. A lot of us are going to Australia to live. Legal obligations and liabilities, how they manage the funds, what and how they sell assets, such as a house or car, who they distribute to, the beneficiaries, paperwork, probate applications, tax returns, financial statements, communications to the beneficiaries. So there is quite a lot of responsibility for the executor, wouldn't you say, Sue?
Absolutely. So that's the benefit of having public trust as your executor, because you've got that transparency. We read public trust as executor. We have transparency not only through ministerial responsibilities as a Crown-owned entity, but we also offer an independent review through the Financial Services Complaints Limited, who are an independent dispute resolution service, which audit our fees and charges and associated activities at no cost to the beneficiary's estate. So, public trust, we're here to carry out your wishes of your will with professionalism, impartiality, and independence. When your loved ones are grieving, we step in as a trusted representative to manage your estate with care and integrity. Public trust as your executor and trustee, we ensure that your intentions are honoured, your assets are protected, and your beneficiaries are supported, all while relieving your family and friends of the administration burden during a difficult time. What do you think, Kerry?
Oh, well, for me personally, the benefit of having public trust as an executor is having the space and time to process grief, losing a loved one, and having peace of mind knowing that public trust have got it all covered from the beginning to the end. A common question we get asked about the cost and time of estate administration. So every estate is different. Most estates take 6 months or longer to finalise, which is often a legal requirement. The cost depends on the complexity of the estate rather than the value of the assets. And we'd encourage you to come and talk to us about if you're thinking of naming a professional as your executor or need help with an estate that you are administering, and we can help make things clearer for you. Sue, can my will be challenged?
Yes, it can. There are several acts of legislation that cover a will and an estate. One of the, as an example, there was an estate where there was a deceased person that left his only child a gift of money. It was about 190,000. He then gave another gift to that child's children, his grandchildren, of $1 million. And then he gave $3 million to charity. So his only child made a claim on the estate. And the ruling was that, with the reasons why the will maker only gave her a small amount of, I guess, smaller gift of money, was that they had given money to that person during their lifetime when they started up a business, and unfortunately that business failed. So she was a bit wary about her child's partner, their business ethics, their work ethics. So that was their reason for giving a smaller amount, but the child made a claim on the estate, and in the end the court ruled that she should receive a greater sum of money and have her mortgage repaid. So there's all sorts of instances, but leaving a disproportionate amount to your only child is definitely a valid claim on an estate.
Oh, wow.
Yeah.
Managing the proceedings would have been time-consuming and stressful, I can imagine. So this emphasises the importance of choosing an executor who has the time and expertise. The next part, we're going to talk about intestate claims. So we spoke about a claim. So people who die without a will can have claims made against them under certain New Zealand legislation also. So one case awarded the neighbour's children a farm valued at $1.4 million due to the neighbour providing meals and including the deceased as a member of their family. If you want a say in what happens with your estate after you die, you need to have a will. So that's an example there. And assets in your sole name over the value of $40,000 in any one category requires a legal process followed in accordance with the law. Assets such as cash, shares, KiwiSaver, bonds, or managed funds, or you have a property, someone, usually your closest living relative, needs to apply to the High Court to be appointed the administrator of the estate. In this situation where you have no will in place, everything you own will be divided up according to the law under the Administration Act 1969. So you can look up this formula online, and there's a clear line of inheritance that includes your spouse and descendants, and finally the state. So if there's absolutely no one, and nobody wants to see their assets go to the state. So the formal process that must be followed to wind up the estate takes longer and costs more than if you do have a will, and everything might not happen the way you'd like. So having a will can greatly reduce complexity. Sue.
Thank you. The executor role holds a lot of responsibility, time commitments, and liability pertaining to their actions. An executor can also end up being involved in legal proceedings should the will be challenged.
Right.
What makes a good executor there, Kerry?
A good executor is, oh, I'm lost. Hang on, sorry, I've jumped a page. I'll just come back. For me, a good executor is someone who's trustworthy, someone or an organisation that is trustworthy, reliable, have time and expertise, and most importantly, have the best interests of the estate and beneficiaries at heart.
Thank you. If no one is eligible or named, or the named person doesn't wish to undertake the process, the family can request public trust through our Executor Assist service. So, please do get in touch if you need an assistance where there's a will, where there is a family member or a friend nominated as the executor and trustee. However, if the estate is a small one, having no property or no assets worth more than 40,000 in any one category, it will not be necessary for administration. In this situation, your next of kin can assume the role of administrator and distribute the estate themselves. Having a will gives your family and friends peace of mind during that grieving process.
Yeah, so true. So we'll talk about blended family issues, as it's more and more common to have blended families. I have a blended whānau of my own, and so I know what I'm talking about when it comes to this. It's important to know how to approach estate planning if you or your loved one is in this situation. So I'm going to answer a common question here. So how does marriage and prenups affect your will? It's a double-edged question, actually. And then the other part to it is, what about divorce or just separation? So I'll start off by talking about when you get married. So in Aotearoa, getting married automatically revokes any will you made before the marriage, unless your will explicitly states it was made in contemplation of that specific marriage. If your will is revoked and you haven't made a new one, you will die intestate, meaning your estate will be distributed according to the Administration Act 1969 that we just spoke about. Now, if you are contemplating getting married or divorced when making your will, let it be known. Chat with the trustee or expert about it, as that specific clause can be added to your will to cover the upcoming change in circumstance. We're talking about separation now. So a separation alone does not change your will, but divorce or dissolution of marriage, civil union, automatically revokes any gifts or appointments for your ex-spouse in the will. So it's like treating them as if they've died before you. For de facto relationships, though, separation has no legal impact on your will at all. It is crucial to update your will as soon as possible after separation to ensure it reflects your current circumstances or current wishes, as otherwise your ex-partner could still inherit or manage your estate. Now, we'll talk about a prenup or contracting out agreement just briefly. So a prenup or contracting out agreement is a legal document that allows couples in a de facto relationship, civil union or marriage to opt out of the default equal sharing rules of the Property Relationships Act. The agreement specifies how property and debts will be divided if the relationship ends. It's protecting individual assets, providing certainty and reducing potential conflict. To be a valid contracting out agreement, it must be in writing, signed by both parties, and both parties must receive independent legal advice before signing, with their signatures witnessed by a lawyer. Sue, what happens when ex-partners make claims on an estate?
Well, thanks, Kerry. I think you've mentioned that if there's a separation and you've divided up the assets and you've gone your separate ways, make a new will if that person is named in the will. So there's a complete separation, so that you can move forward. Any joint assets are obviously going to be closed at the time, and so you make sure that all your assets are separated so that any ex-partner has no claim on your future estate. Just make it a clean slate and get those loose ends tidied up. I was also going to talk about family trusts. A lot of people might want to hold their property in a family trust, and particularly if you've got a blended family, or if certainly a family trust is a great vehicle for protecting a major asset. We would recommend you come into public trust to talk about family trusts, or we can even have a look at your existing family trust. With the new Trust Act that came in 2021, the Trust Act of 2019, there's new legislation to consider. So it's a more complex situation, but we certainly recommend you come into public trust and we can help you with that.
Awesome. Sue, can you tell us a bit about the changes that were in the Trust Act 2019?
Absolutely. So it's all about being clear and transparent. All the named beneficiaries must be acknowledged and provided with information. A new family trust now runs for a period of 125 years, whereas previously it was only 80 years. And another common factor is that previously adults were recognised at age 20, and now they're recognised at age 18. Yeah. So there's a lot there to go through.
Also, I think tax has gone up from 33% to 39%. And about being transparent, you should be providing basic trust information to all beneficiaries of the trust.
Yeah, that's right.
Yeah. So another question that I'm going to answer is including, excluding children from previous marriages. So we're talking about stepchildren. Blended whānau, unlike biological children, stepchildren are not considered natural heirs and do not have an automatic right to a parent's estate unless the step-parent has named the stepchildren in their will, or they were adopted, or are financially dependent on the step-parent at the time of death. So if you intend to provide for your stepchildren, please chat with a trustee or expert to help structure your will to ensure that the well-being of your respective children, so you have your own children and their stepchildren as well, are adequately covered and everyone is treated fairly.
Absolutely. There's also a situation there where we meet couples that have they've kept their assets separate. So an estate, when someone passes away, an estate deals with those solely named assets. So it's great that if you kept everything separate, any joint asset would default to the survivor. So, any sole name asset is dealt with in your estate, and we follow the wishes of your will and how those assets are distributed.
Yeah, very good. So I think we're going to pause just quickly for Q&A. So we'll just check our Q&A to see if we can answer some of those burning questions. Having a look now. Maripur, if I want to stroke out an ex-partner in claiming estate, do I need to mention it on the will? So earlier I spoke about a statement to accompany your will. This is where you would explain why you want to strike out or leave your ex-partner out. And also you need to also talk about how long have you been separated for? How long were you with the ex-partner? Do you have any agreements in place, or have, as Sue mentioned, have you talked about separating your assets already? Have those kind of things been dealt with and settled? What about you, Sue? How would you answer that question there?
I think the statement of account would be a good place where you could explain that that this person, this ex-partner, has no claim on your estate, that everything is sorted, and that statement to accompany the will accompanies your main will. So you don't have to mention that person in your will, but in the document that accompanies the will, where you can put a bit more information about, the back history of the relationship.
Yeah. So Shani, what would be cost of a will and looking to encourage my whānau? Awesome to start their process. But if it's too far out of their budget, I know they won't do it. Well, good news is there are two options that Public Trust provide. There's an option where you can go online and make your will online, and we've actually brought the costs down for our online platform if you want to make your will or enduring powers of attorney documents there. Or if you would prefer to come into our contact centre, not contact centre, customer centres, we've got about 20 nationwide, and come in and have a chat with us, or call our 0800 number and arrange an appointment.
Awesome.
Yeah. Do you want to have a look at the next question by Kerry?
Let's see.
I can answer that. So
Okay.
jointly owned asset, it's not solely owned, does not form your estate. It does not come into your estate. So the surviving owner will, carry on with that jointly owned asset.
Right, I'm just scrolling through all those questions.
Yeah. So
there's some really good ones
things that
there.
do form your estate, Kerry,
me.
are things in your sole name. Julie, a statement of wishes could be something like, please see if any of my friends want my jewellery better worded. Oh, yeah. It's a good way to list any further instructions, but it's not part of your will. And it's a good idea to have a talk with your friends and let them know, I'd like you to have this, or even better, give it to your friends while you're alive.
Well, that's nice.
Yeah.
I'm just looking at Shari Scanlon, the kia ora, does the Kiwi balance go to the beneficiaries KiwiSaver, or is it withdrawn as cash? So if we were dealing with your estate, Shari, and you had a KiwiSaver, we then write to that KiwiSaver provider and get the funds into the estate, and then it's distributed to the named beneficiaries in your will.
Yeah.
But certainly I hear what you're saying about it being transferred into the beneficiaries KiwiSaver, because that would be a great way for them to increase their investment for their future. But that would be something that we could have to talk more about, or at least maybe with your KiwiSaver provider, if that could be done as well.
Yeah. Good answer. So, all right, we'll jump back into the next screen. Sue, do you want to just kick us off with the big decisions?
Thanks, Kerry. Now we've covered off what happens when you die, what happens while you're still around, but unable to make the big calls. You never know when you might need someone else to make a big decision for you on your behalf. An enduring power of attorney is like a living will. It's a legal document that allows you to choose a family member, friend, or organisation like Public Trust as an attorney to make important decisions on your behalf if you're not able to due to injury or illness. They can immediately step in to act for you, ensuring you are taken care of in a way that you'd like.
Yeah, you're going to hear us refer to enduring powers of attorney as EPAs. So I'll kick off by saying EPAs are not just for old people. I guarantee that we will know someone who has had a fall, been in an accident, had a medical event, suffering a brain injury, stroke, heart attack, or got injured from sports or work, got concussion. Any of these events could lead to losing the capacity to make decisions for yourself or losing the ability to sign documentation. Each of these situations are relevant to everyone, young or not so young. And EPA means information, decisions, and actions needed could be made immediately without delay of court proceedings. So,
your physical and financial welfare is important. By having an enduring power of attorney, you're covered if something does happen, like your everyday insurance. Enduring powers of attorney are there for you when you need them, but only if they are in place before they are needed. Not just for illness. You could be injured, you could be stuck overseas, or you would just like someone to step in for you just in case. So they're very important documents to have.
Yeah. So I'll talk about, so there are two EPAs. One is property, so I'll talk about the property EPA. It covers personal property, assets and liabilities in your name, e.g. bank accounts and services billed to your name like power, phone, etc. Your property EPA names the attorneys which are the people or organisation you've chosen to make decisions on your behalf regarding your property and financial affairs. A suitable attorney is someone or the organisation who is reliable, trustworthy, I mentioned this before, has time, the expertise, and importantly, who will act in your best interest to make decisions on your behalf. Sue, please explain the welfare EPA.
Kerry, the welfare enduring power of attorney or personal care and welfare enduring power of attorney is a legal document where you appoint family or friends, not an organisation like Public Trust, but family or friends, those that you know well and trust that will make those decisions for you when needed. So you have a first attorney and a backup, and they make those important decisions if you become mentally incapable. A doctor may have made that assessment. Well, only a doctor can make those assessments. So if you've been deemed mentally incapable, your personal care and welfare attorney decides where you're going to be best cared for. So choose people you know well and trust, who know your wishes of where you would like to go and how you'd like to be treated.
Yeah. So when do EPAs take effect?
Absolutely. So with the personal care and welfare attorney, it's on a doctor's assessment that you've become mentally incapable. But with the property enduring power of attorney or the financial one, they can be invoked on your say-so. Like if you were going overseas and you wanted somebody to look after a particular bank account or a particular asset, it doesn't have to be invoked if you are mentally incapable, but obviously if you've been assessed as being mentally incapable, then the financial one will also be invoked.
Yeah. How does capacity work?
So capacity is only something that a doctor can assess. And if you have your enduring power of attorney only invoked if you become mentally incapable, well, it may never happen. You may never become mentally incapable. So that's why we always recommend the financial enduring power of attorney that you have effective immediately, because it's only invoked on your say so.
Yeah, that's a good point.
So
Okay. So yes, EPAs can be turned off or revoked when, and when should I review them? So yes, the donor, that's the fancy name for the EPA owner, can change the appointment of the attorney or the terms of the EPA at any time, providing that they have the capacity that Sue just spoke about. If the donor wants to make these changes, then new legal documents need to be drawn up and signed accordingly. The appointment of an attorney may be revoked or cancelled by the donor, death of the donor, attorney who wants to disclaim or renounce their appointment, and or the family court. So all revocations must be sent to the attorney in writing, as this is a requirement of the Protection of Personal and Property Rights Act. So you should review your EPAs when you review your will every 2 to 5 years, or if your attorneys or your circumstances have changed. Now we're just going to check on the Q&A if anybody has any questions regarding EPAs. And also, if you don't have any questions, I just thought of something. A lot of people don't realise that the documents need to be fully signed by all attorneys as well as the donor, but needs to be fully signed before they are valid.
that's right.
Or legally binding, yes. I'll just have a quick look in chats to see if there's anything in there. Oh, there is. Oh, sorry. Okay. Does a KiwiSaver balance go? Oh, we've answered that one. If my partner has recently been divorced and partner creates a new will, can the ex-partner contest the will, even though I am the EPA? So you've divorced, so you've settled your assets and liabilities, is that correct? Your assets and debts? Daniel? If you have, well, as explained before, let me see. A divorce has effectively written themselves out of the will. Well, that's the wrong wording. So it's like they've died. So what if you've provided for your partner in your will and you've now divorced, that gift is going to fail. And creates a new will. Okay, so you create a new will. You do not need to include your divorced ex-partner. What do you think, Sue? Anything else there?
That's a lot there that probably need a bit of one-on-one time, maybe.
Yeah, true. It is quite specific, and this is where our experts can provide assistance when you're making a new will there. Maru, Calvin, thank you. Sorry, I have to go. Oh, I'm sorry that you had to go, Calvin. All right, so we'll get back to the next slide. Okay, so the big thing with EPAs is to think of them like insurance. You need to have them in place before you think you'll need them, and you can keep them up to date as life changes. Remember, your partner does not automatically have power of attorney for your solely named assets and liabilities. If you get a new partner, if you had appointed your ex-partner as your attorney, you might want to make new EPAs to revoke the old ones where your ex-partner was your attorney. If you have complicated family dynamics, it's good to have an EPA so family is clear on your wishes. And EPAs for going overseas. Sue talked about this just a little bit before. So EPAs aren't just for old people. With travel being so common nowadays, having an EPA in place enables someone in New Zealand to renew important identity documents should you ever lose your passport while traveling. And they also would be able to manage your bills, make sure that they're paid while you're away and traveling. Sue, is there anything you'd like to add here?
I think that's covered. I mean, we've got our wills and EPAs are built to fit any situation, from the simplest to the most complex. They're easy and affordable to do online, but if you need us, then we're here to help. Just like you mentioned before, Kerry, the wills must be printed and signed and witnessed correctly by a professional. Yeah. And we include that, these appointments in our price. Yeah, and there's various ways that you can reach us. Our 0800 number, 0800 371 471, or if you want to book an online appointment, 0800 279 792, where we have digital trustees via a live chat 7 days a week.
Yep, true. Once you've completed your online will, you would download it then to print and sign it with 2 witnesses for it to be valid. Keep it in a safe place. Let your executor know where to find it when the time comes. When you are the donor signing your EPAs made through public trust, it must be witnessed by public trustee in person. And times have changed now where it is the norm to provide a certificate of capacity to add that extra layer of validity to your will or EPAs. Also, we have changed our pricing, so if you make your will with public trust online or in centre alongside one of our experts, you are entitled to an annual free update every year. Terms and conditions apply there. If you are happy with your will, though, and choose not to update it so soon, it is advisable to review it along with your EPAs if you have them every 2 to 5 years. All right, and now we'll just break for any questions.
A couple of good ones in the Q&A, Kerry.
Yeah.
Oops, I'm getting slack. Sorry, I'll just pull up the Q&A.
Is that good one about the retirement village?
Or would you like to answer that one there, Sue?
Or Breezel, Regira. I work in a retirement village. Some of the family who are named as enduring power of attorney and property always say that the EPA for property is already activated since it is a living document. But we do explain that it needs to be activated by the resident's GP. How is it explained to the family when the EPA is applied? Thank you. Well, with the property enduring power of attorney, you've got 2 options: that it can be invoked only if you're mentally incapable, or invoked straight away. So we always, when we have a customer come in to do enduring powers of attorney, we always talk about that at great lengths, because, like I mentioned before, you may never become mentally incapable. And so effectively that document would be ineffective if it were needed. So we recommend that you have your property enduring power of attorney activated on your say-so while you're mentally capable. And if you become mentally incapable, then your GP or doctor that's qualified to do the assessments would make an assessment. And if you were deemed mentally incapable, then that document is also activated and valid. I hope that explains that for you.
Okay, Sue. Kerry, if you were terminally ill and withdrew the KiwiSaver early and put it into your partner's account, would that form part of your estate still? No, it would not. So you've effectively, it's your partner's now. It's in your partner's account. Okay, so it's not in your name any longer.
Yeah. A shared asset.
Yes, yes. Is an executor the same as an administrator? The same things or the same role? Yes, I would say yes to that. What would you say, Sue?
I would say that an executor and trustee is named in your will. Quite often, if there is no will, then if the person that's administering the estate is called the administrator. So, and that's another court document called Letters of Administration, which allows that person to carry out the wishes of the will.
Great answer. In respect of what needs to be done with administering the estate, they're the same. So you're applying to the courts, you're doing the paperwork, you're looking after the beneficiaries, and so on.
That's right.
Yeah. Brazil, may I please ask, believe it. But will it need payment beforehand, or it will be deducted for how much and I have left? Oh, that's a great question, Brazil, regarding public trust to be an executor or assist the executor by applying to the High Court for grant of probate. It can be done in a couple of ways, and you can also list it in your will if you choose to. Choose the administrator or the professional organisation to assist with parts of the administration of your will, or you can choose public trust directly to be your executor of your will. As for costs, I would recommend getting in touch with us and we could talk you through that because it does depend what you would like your executor to do. It can be done in parts, like just applying to the High Court for probate, or the executor could do the whole estate administration.
Yeah.
There's a few more Q&As, so we'll try and get through them quickly. Are wills public? Yep. Are wills public information, or can the government access the information? Wills are not public information until or unless they have been granted probate. Then it is on public record.
Yeah.
Yeah.
And there's also a notice to creditors that if public trust is administering the estate as executor and trustee, one of our duties is to do a notice to creditors in a local paper. Yeah.
Very good. So wills, to state it again, is your private information. It's your will, and it's not public. Only once it's been granted probate or granted administration, it's then on public record. So are you covering the questions that were submitted as part of signing up to attend this session? Oh, I'm sorry, I have not seen those questions, Anusha, but once I have a look, we'll be able to get back to you. Averagely, how many hours would be needed to sort out an estate where the executors and beneficiaries live overseas? So we mentioned this earlier. So on average, it starts from 20 hours, but dealing with beneficiaries and assets perhaps overseas would take longer. You would have to factor in a lot more time because you would need to be corresponding as well as arranging certain things to collect any assets over there as well, and dealing with the legislations in that country as well. Sue, did you want to add to that one?
I am sorry, there's so many questions.
Oh, there
I'm
is.
just like scrolling through trying to catch up.
Okay.
The
Well, we can stop there and we'll just carry on and we'll try and answer all of the questions that are in front of us. So,
There's one there, Kerry, about a home going into a family trust, or if you own a home, can that home be transferred to a family trust, or is there a separate process for that? Certainly, if you were thinking about transferring your home into a family trust, that would be definitely a good opportunity for a face-to-face meeting at one of our customer centres, because we can give you a whole bunch of information, because there's lots to think about, lots of who to include in your family trust, how the asset is owned, is there a mortgage? So it's quite a complex question, but certainly please give us a call and we'd be more than happy to help you out there.
Yep. Melanie, can I appoint more than one attorney or executor, and what happens if they disagree? Yes, you can appoint more than one attorney or executor. You would consider, do you want them to act jointly, or do you want them to act jointly and severally? Whereas, for example, jointly and severally, you've got one attorney in New Zealand, one overseas. So the one in New Zealand, a document is required to be signed, so the one in New Zealand is able to sign that document, but they've made the decision together that yes, the one in New Zealand can sign that document. If they were operating jointly only, they would both have to sign that document. So that's an example, and it can cause disagreements. So those are things you need to consider when you're appointing more than one attorney or executor of your will to act. Are they going to get along? Are they going to make decisions, in the best interests of the estate and beneficiaries?
Absolutely.
So the next question. Deepak Valley. If you have property abroad, what we do here is you can let the trustee know that you do have overseas assets, and they will discuss with you how you want this to show in your will, as in you can mention it that you do have assets in your overseas. They may need different types of legislation. So we always, or not always, we often recommend that you consider making a will for that asset, especially if it's a large asset in that country.
Absolutely. Yeah.
If you own a home, can that home be transferred to a family trust? Oh, you've answered that one. And it was a good answer, Sue. The time and effort involved in being an executor or executrix can be extensive in terms of time, effort, especially if there are a number of beneficiaries. Yes, absolutely true. Is there room for this role to be paid, like the role of administrator, public trust? So, yeah.
That would have to be the will maker would have made that decision when they made the will. Yeah.
That is a good question. So that would, the will maker might want to set aside some funds in a separate bank account for the specific executor to help them cover out-of-pocket expenses. So you'd be thinking along the lines as the will maker, okay, how can I provide for my executor? How can I look after them and pay for their time? So you might want to set up a separate bank account to cover that. And then you would let your trustee know, or the expert know, or note it that this bank account is specifically for that person. That's one way to look at it. Yeah.
I think we might be closing off now.
Okay. All right. All right. So thank you for the opportunity to kōrero and raise awareness about estate planning with you. Please feel free to contact us. We can help you with your planning. We're located throughout Aotearoa and online. You'll be provided a link to the website with our fees, charges and relevant information. I te mea whakamutunga tēnei ka mihi ki a koutou mō tō koutou manawa nui tanga kia mātou. Pai kite ki a koutou tino nui te kaupapa I tēnei hui. Kei te mihi ki a kōrua, ko Sue, me Felix, me Elizabeth mō o koutou pukenga o ēnei kaupapa. He pai rawa ake ko koutou mahi. Hei whakakapi tēnei hui I te karakia. So I'll just do the closing karakia. Tuia te taura tangata ki te aroha maurua, kia maia, kia marama, kia tapatahi, te kākahu I te tangata, ki te kahu taurima, e mauai. Ko te kura nui, ko te kura roa, haumi e, hui e, tai ki e.
Thank you so much. Thanks for coming.
Thank you.